Bowser again at Roth Jackson, here for another edition of our TCPA compliance seminars. Today we're going to be talking about the differences between B2B and B2C calling. This is how you all often think about your call campaigns. On the one hand, you may be calling consumers, so you're thinking B2C, and if you focus on the business market, you're thinking B2B. But the TCPA and Congress don't think in those terms. The TCPA at a high level has two different parts. 227B is the first subsection that prohibits using certain kinds of technology to certain kinds of phone lines. And then section 227C are the so-called do not call or DNC rules. So that's how Congress structured the law, and that's how we're going to talk about it today. So when you think about 227B compliance, you think first about the regulated technologies covered by 227B. And those are an automatic telephone dialing system, or ATDS, or pre-recorded or artificial voice. So if you're not using one of those technologies, an ATDS or pre-recorded or artificial voice, you check the box that you don't need to worry about 227B. If you're using an ATDS, pre-recorded or artificial voice, then you need to think about what types of phone lines you're calling. And 227B largely restricts calls to cell phones, although it also extends to pre-recorded calls to residential lines. Congress also regulated calls to, you can't call emergency centers, you can't call hospitals, elderly care centers, things like that. But the key source of litigation for 227B claims are pre-recorded and artificial voice calls to cell phones. I left out auto dialer there because after the Supreme Court's decision in Facebook versus DeGuide in 2021, it is hard to find an auto dialer in America anymore because the way Congress defined ATDS requires the system to generate the numbers to be called. At Readymode, there are no number generating capabilities. If you do not tell the Readymode platform what number you want to call, it's not going to call anybody. So at least at Readymode, you really don't need to worry about an auto dialer. Some courts still allow a plaintiff's case to survive a motion to dismiss if you're just cold calling strangers and there's no plausible explanation for why you were calling them. That said, the plaintiff would still have to prove that it really was a call made with an auto dialer in the first place. So these days, 227B cases really focus on pre-recorded and artificial voice calls. But again, none of this matters about whether it's a call to a consumer or a call to a business. If the business is using a cell phone, it's a 227B call if it includes artificial or pre-recorded voice. If it's a pre-recorded or artificial voice call to a consumer, 227B can also apply. You want to have consent for both of those kinds of calls. 227C, on the other hand, doesn't talk about the type of technology. It focuses on the type of call that you're making. So 227C regulates telephone solicitations to residential telephones. It's tempting to think that residential means only landlines. For a while that was true, but in 2003, the FCC expanded the application of residential lines to include cell phones. Recent Supreme Court changes will cause that decision to be litigated again. We won't get into that today, but that there will be fresh attacks on that decision and the extent to which the FCC had statutory authority to do that in 2003. But if you're being cautious and risk averse, if you are making telephone solicitations, and we'll get to what that means in a second, you will want to be careful about whether you're calling landlines or cell phones. But the FCC and courts have been clear that given Congress's protection of residential lines by name in the TCPA and subsection C specifically, they do not protect business lines. So B2B calling is safer under the DNC section of the TCPA. The hard part there is being confident and clear that you really are calling a business line. Because with the obvious proliferation of cell phones, lots of folks, me included, use a cell phone for business and personal use. So a realtor, for example, or someone with a small business may list a cell phone that they use for their personal life as their work line on public forms. If they're registering as a health professional, a realtor, or some other licensed profession, even with government regulators, typically state regulators, who require registration of those sorts of licensed professionals, it may still be a cell phone. Now, for B2B callers, there are pretty reliable sources of data about which numbers are associated with a cell phone, because a particular phone number will have a local routing number associated with a wireless carrier. So you are capable of taking your lists and scrubbing them as best you can against a wireless number databases. So there are commercial services to do that prophylactically if you're not 100% sure that the number you're calling is in fact a business line. So to recap, for 227B purposes, there is no distinction between business and consumer. If you are using the regulated technology, i.e. ATDS, pre-recorded or artificial voice, to call the types of lines that are protected under 227B, it doesn't matter if it's a consumer or a business. But on the 227C side, that is a much safer place for businesses calling other business customers, as long as you're confident that it really is a business line. Now, that doesn't mean to say that you cannot call residential and cell phones if you're making B2C calls. You can make those calls under a variety of circumstances. So, if it's not a telephone solicitation, and a telephone solicitation is any type of call where the purpose of the call is to encourage the called party to purchase, buy, invest in, lease something that you're selling, goods, services, property, etc., right? So if you are calling someone about political issues, or to perhaps purchase something from them, or market research, right? There's a whole host of call types where you are not trying to sell them something. And lots of cases would hold that those are just not telephone solicitations protected by 227C in the first place. But even if you are making sales calls, you're selling widgets of any kind, you can make those calls with what the TCPA calls prior express invitation or permission, commonly known as consent. It doesn't need to be the fancy kind of consent that you need to make telemarketing pre-recorded voice calls, which requires prior express written consent that has a host of required elements to it. So consent for 227C telephone solicitation calls can look more casual than prior express written consent required for 227B calls. So you can get consent, and then you can call people on the DNC. Other exceptions to the 227C telephone solicitation rules are having an established business relationship. So if you call a car dealership and you go and see them, or don't go and see them, but you call and ask about one of their vehicles, they can call you for up to 90 days to try to close that deal, unless and until you tell them that you don't want to hear from them anymore, right? If you bought another car, or you're just not in the market, or don't want to hear from them, you can make that internal DNC request, and the dealership would have to respect that. But if you make an inquiry to a business in the store, over the phone, some other way, the business can then call you, even if your number's on the DNC, for 90 days to try to conclude that transaction, as long as they don't make an earlier internal DNC request. Now, if you already have a commercial relationship with the business, they can still call you to sell you other things. for the life of the transaction and another 18 months. So if you have a commercial relationship with a bank, for a checking account, they can try to reach you, even if your number's on the DNC, by a live agent call or text message. As long as you haven't made an internal DNC request for them, as long as you have the checking account, and they can try to sell you a credit card or some other financial product that they sell for 18 months after your relationship ends. Again, unless and until you make an earlier internal DNC request to that institution. So, again, the TCPA doesn't think in terms of B2B and B2C. You have to think in terms of how the TCPA is structured. So you want to look at the two different prongs, 227B on the one hand, that's regulating ATDS or auto dialer technology and pre-recorded and artificial voice, primarily to cell phones and residential lines. And then if you're making sales calls or telephone solicitations, as the TCPA calls them, then you need to think about what are your exemptions, right? Do you have an EBR? Do you have consent? If not, and you're making sales calls, you want to get a scrubbing service involved. You want to get a SAN, a subscription account number from the FTC, to get your calling list scrubbed so that you can make legal cold sales calls to phone numbers that are not on the National Do Not Call Registry. And Readymode has integrations to help you with that, with DNC.com and other Do Not Call registry scrubbing services. So that's the recap today for B2B and B2C calling. Thanks for watching.